Well, hello and welcome. It's a big topic today. We're looking, has the AG thrown in the towel over the Woyome case? If you look on my Joy Online, was promoting the show, is asking what's happening to the 51 million. And that's exactly what we're going to find here. I need to keep my intro short, but there's so many things to read, to catch up, to bring us to, how it is that we got here. My name is Nana Sapkwao the fourth. Komodo Masahini, and also your host. Now, my guest, I have Sydney Casely Hayford, member of Occupy Ghana, and I have Kojoga Adawudu, private legal practitioner, all here. Right after the break, we'll start talking. Well, thank you very much for staying. And just to give you the chronicles or the saga of the Woyome case, how it is that we got here. This is an excerpt that Asankoma, summarized and put on his Facebook. So I'll just quickly read it out and then we'll come here. So bear with me, but it will help us. Now, this is around 2005, the government engaged an Austrian company called Vermut to undertake some construction work in Ghana. But it turned out that they were really talking at cross purpose. While the government was talking about building stadia, Vermut was only interested in building hospitals. Vermut lost interest in the deal and therefore purported to assign its rights and obligations to another company called Waterville. Woyome claims that he led a consortium of Vermut, Waterville, and Empower Park to win a bid to construct 5 new stadia and rehabilitate 3 others. However, note the following. 1. Vermut left the scene. 2. The actual contract was between Ghana and Waterville alone. No Woyome, no Empower Park. 3. The contract I have seen, i.e. Asankoma, the contract I have seen was limited to the rehabilitation of Accra, Kumasi, and Elwak stadia. Nothing about building 5 new stadia. It goes on to say, let's pause here and do a little law. Section 20 of the State Property and Contract Act limits the power to contract on behalf of the state to the relevant sector minister or a person duly authorized by him. Thus, unless a person can produce any such contract, the person has absolutely no contractual relationship with the state. There is nothing to enforce you if you don't have a contract. You might have heard Woyome admit many times on air that he did not have a contract with government. That is true. We will return to this later. The contract with Waterville was signed on behalf of the state by Osafo Mafu, a former Minister of Youth and Sport, and witnessed by a principal state attorney, Mr. Kweku Agyemang-Manu, the then Deputy Minister of Finance, and witnessed by a legal director at the Ministry of Finance and Economic Planning. Under the contract, Waterville was to produce funds for the rehabilitation projects. Subsequently, Mr. Agyemang-Manu wrote a letter of introduction for Waterville, Woyome, and another to 3 banks, but stated clearly that there was no power in them to enter into any contract, and that if they agreed on something, the term sheet should be brought to Ghana for approval. Why Woyome? Clearly, he was a part of this deal, but officially as the local agent of Vermut, and now almost by default the agent of Waterville. But the letter was clear that none of the persons mentioned in it had the power to enter into any contract. Note that it is this letter that the former Attorney General subsequently discovered and rushed to court to say that on the strength of this letter, she made a mistake when she thought and argued that we had a contract with Woyome. I will return to this later. Notwithstanding the above, Woyome claims in his statement of claim that he arranged 1 billion euros with the bank and that he had arranged with the state that he would be paid 2% of the project cost. Once again, he's unable to produce a contract under which he was to be paid any such monies. Note that he says he arranged the funds, but the introduction letter was emphatic that whatever they did was not binding on the state until the state had directly contracted the bank. In any event, according to Woyome, this amount was to cover the construction of 5 new stadia, rehabilitation of 3 stadia, the construction of 6 hospitals, a cobalt plant, and a tissue plant. Now let's go back. The only contract in existence was for rehabilitation of 3 existing stadia. Even if we were to assume that Woyome had power to arrange funding for the contract, which he denied, who gave him power to extend to cover all the other projects and then claim a 2% fee for all that? If you send me to go and hire a taxi for you for a fee, can I hire a taxi, a trotter, a U-turn bus, a bicycle, and say you should pay me a fee covering all that? As things stand out, Waterville ran into difficulty in raising funds for the stadium rehabilitation, and time was running out, so the government terminated the contract. Waterville wrote to accept the termination and made a claim for a specific sum. The government disagreed and asked the project consultant to do a relevant measurement of work done, materials on site, and already purchased but not yet delivered materials. This was done and Waterville was paid through its local subcontractor, Micheletti and Consa. It's obvious that Waterville was not happy with how much it was paid, but this was certified by the project consultant. Then there was a change in power. Waterville then surfaced again to make claims way in excess of even what they had originally made in their letter to the previous government when it wrote to accept the termination. Somehow, Woyome heard about this and wrote an angry letter saying that Waterville was lying and that in his view, Waterville was owed about 5 million euros and he, Woyome, was owed 6 million euros. This brought a quick reaction from Waterville's lawyers, who reminded the AG that there was no contract with Woyome and stated that Waterville had already paid Woyome off for his work and services and signed a termination agreement with him. I have seen the termination agreement. I will look for it and post it on my page. Soon after this, Waterville's lawyers were fired. Waterville and Woyome became one. Waterville then put in a claim for construction and financial engineering of 32 million euro. Arbitration and nagging questions. We are told that this went for arbitration and that we were made to pay Waterville some huge sums of money. People in government have said it was 25 million euro. Arbitration? Where? Who was the arbiter? How was he appointed? Where is the notice of arbitration? Under the contract, it was supposed to be under ICSID rules and held in London. Where are the pleadings? Where are the recordings of proceedings of the hearing? Where is the award? Woyome, however, gives the game away in his pleadings when he says that it was rather an interim agreement between Waterville and the government and that we paid 21.5 million euros. But then he says the payment only covered construction and not his financial engineering. Remember that Waterville had accepted the termination in writing and had been paid, leaving a rather small claim that we were refusing to pay because the project consultant did not certify it. Remember also that Woyome had claimed on whatever basis that we did not owe Waterville more than 6 million euros. but we ended up paying over 20 million euros to Waterbill. That is the chronicle of this 51 million that we've been chasing since time immemorial. And today, the Occupy Ghana came up with a statement which is saying that, well, they have seen that this Attorney General has gone, the case is dragged all the way to Supreme Court, but now Attorney General is saying, look, I'm going to withdraw the case, and whatever it is, that's what we're here to explain. Gentlemen, thank you very much.
Nana, it's a pleasure.
Yes. One of my two favorite guys. I've never met them here before, but and they are seven, so I need big guys to explain it. I don't know where to start with. Let's start with the lawyer. Everybody panics, and then this 51 million just gets all sentiment over the place, you know. So I was asking today, I mean, is there a legal justification, or should we panic? Now, before you come in, 6 p.m. news on Joy FM, lawyer Amaliba, who says he's speaking on authority, said to Jifa that, no, the reason why they are withdrawing the case from the Supreme Court is because the AG had a meeting with Woyome, and if the meeting doesn't go well, they will refile the suit. If it goes well, then they pull it out. Help us out.
Anyway, good evening to cherished viewers. But before I come to the substantive question about what Amaliba said, is that what the chronicle that my learned friend and senior has put there is not entirely correct, right? Because I knew, and I believe there had been a mediation and arbitration in this matter. It was done in Ghana here by 2 lawyers. Speak no ill of the dead. Eko Nyamiche Awuno was the one who did the mediation, and Piasa Buedu was also for Waterville. It is on record. They have everything there. So if they're asking that all this, that it cannot be found, I don't think it is right. Okay. Also, for him, also, he's a member of Occupy Ghana. So coming on this, the way he has put it, the chronicle, you know, might not give the accurate fact as it is. Now, coming to the issue where the AG has filed a notice for discontinuance or withdrawal with the leave of the court, I believe this is permissible by the law, by the rules of procedure to the court. You are allowed that when you are a plaintiff, you send your matter to court or you have an issue, the rules allow you that you can discontinue without leave. You can discontinue with the leave of the court. Let me explain this too. And we use these 2 words interchangeably, discontinuance and withdrawal. These are the 2 words that are used. Now, when you discontinue without leave, that means that you are no more interested in the matter. You can't come back or file the same issue or matter before another court. Let's say I'm doing the case before you, Nana. Then I will discontinue from where your court, and I'll come to Sydney's court with the same issue. No, you don't have to do forum shopping, so you can't do that. The other one is that because of this principle, you have to have the leave of the court. Tell the court the reasons or why you think that I have brought my opponent to court and I don't want the matter to continue. So if it is with leave, then you can ask the court that I want to withdraw with leave or liberty to reapply. Now, if you say with liberty to reapply, is that I've identified or there's an issue with my process, or I've identified there are some reasons. So I want some respite that when I go, I should be able to come back to the same court with the same matter and the same parties. So you have to file, and you file a motion and affidavit, you state your reasons and others, you give fair hearing to the other parties why you want to withdraw or discontinue at that time with leave, so that you can come back. It's not that for you to go and rehash and you think that, oh, there's some issue I've left out, and come back. So the court would want to know why you want to. And I believe that what the AG has done is permissible by law, that you can file for discontinuance, but with the leave. The mere fact that you have filed in court does not mean that you've been granted the leave. You definitely have to go to the court, and the court will now listen to you and grant you an order that we are striking it out, and we are giving you liberty to refile this. It is permissible by the law.
Let me take a quick break here and then find out why Occupy Ghana is panicking. They're just going to rehash the case. Thank you very much for staying. Has the AG thrown in the towel over the Woyome Cash? That's what we are trying to find out here. Good to have Sydney here. I have Kojoka here. And Sydney, the lawyers explained quite eloquently that there's no room for panic. Just withdrawing, and then they're going to, come back. They probably find that there's a T not crossed or an I not dotted. They're going to cross it, dot it, and then bring it back. Send your messages to 0500. I'll give you the, I think the number will be on the screen. But you can also send your tweet, so I'll read it to you. Yeah, it's Nana and Sakwa, at Nana and Sakwa. Send your tweet, and I'll read it out for you. Sydney.
Okay. You'll excuse my voice a little because I've got a bit of a sore throat. You see, nobody is saying she doesn't have the right to discontinue or to file a discontinuance or whichever legal term, or withdraw whichever legal term you want to use. Nobody is saying that at all. I think a few days ago, what the AG did do was to serve notice, or she filed a notice that she would be requesting a verbal inquiry, or she will be invoking the right to actually interrogate Woyome verbally, on a verbal basis.
That's to examine him as to maybe his status, how to be able to pay or not to pay. Yeah.
Yes, and this will be something that will be done in a verbal forum, not.
Is it how he's going to pay or how he spent the money?
No. You see, you can also, as the law used to be, when somebody owes money and you attach the position of the law. Let me explain as how it used to be and how it is now. Now, even when somebody owes, you have to show cause why you should not be sent to prison. So the court will give you the benefit to explain why, whether you can pay or you cannot pay, and the circumstances which are exceptional that you cannot pay. If you explain, the court is satisfied, they give you different terms or not. If it's not satisfied, you are railroaded into jail. Now, with the advent of the human rights and the rights of people, the position of the law changed and said that, look, the fact that somebody owes you money, it should not be against his liberty to go to jail. But take another process that go after his properties, go after his bank account, go after any asset he has to his name. Or if you can trace that I have an asset, but I deliberately put it in the name of Sydney. If I can trace that connection, then the law can stretch its long arm and take the property from Sydney. So that's the process we need to go. So I believe it was in the process of the execution that my information I have, which I believe it is true, is that some of the properties has been attached of Mr. Woyome. Some of the accounts were garnished. When we say we garnish, is that you go to a court gives you an order that bank manager over there, this account is with you, come to court and explain why we should not take that money from that account to satisfy the judgment debt. And I believe that has also been done. So it was a process. And even with that, some people have interpleaded and said that property over there does not belong to Mr. Woyome. It belongs to us. So there are pockets of issues surrounding the whole issue. And that's what is going on.
Right.
Yes.
Okay.
Until my information was that a letter was written by Mr. Woyome to the AG that let's look at a payment plan. I'm ready to pay because the Supreme Court has made an order way back that you owe this money, you need to refund this money. So he has sent a proposal that, look, I need some respite as a citizen. And I believe that it was in all fairness and says that, look, if that is it, let me listen to him, what proposal he has on the table. If I'm not satisfied with it, then I have liberty to go back to court and exact what I want to do.
Let me bring
Sitting.
Yes, so picking up from where I handed over to Adaudu, the thing is this. Woyome has clearly taken something that doesn't belong to him. This has been determined by the court. All right?
Yeah.
The Supreme Court has determined that 51.2 million that was given to him was not something that he was entitled to. And this we have ascertained with the help of Martin Amidu. It wasn't anything that was state evoked. This is a Martin Amidu independent vigilante who took if I'm wrong, just correct my facts and correct my legal drift. I'm trying to establish a case, so just give me that latitude, as you guys will say.
Definitely. Yeah.
So as we sit now, and as the people of Ghana know, Woyome owes this country 51.2 million cedis. That is what we know. We know also that since the judgment was given against him, the Attorney General has supposedly tried to recover this money up until the point where sometime late last year, he comes up and says that he is bankrupt and he doesn't have the money. And there's nothing for us to pursue. He has no properties, he has no business. He's virtually saying that I'm finished. And there's nothing I can give you and I can't find anything from anywhere. Now, this becomes a little incredulous because for anybody to dissipate 51.2 million cedis in 5 or 6 years and not be able to show anything for it sounds like a little bit of an Anansi story. A smart maneuver in
no
all
car,
of this.
no land, nothing.
No land, no car, nothing. And even if he has, they are not worth anything anywhere near the amount. So I believe that the procedure that the AG wanted to apply about a week or so ago was simply to say, I need to ask this man some very pertinent questions. What has he done with the money? Where did it go? If you gave it to somebody, who are these persons? Come to court and let us ask you, and let us be sincere about it, and you under oath must tell us what you have done and where this money has gone to. And the strategy to us at the time, when we wrote a letter on the 25th of October congratulating the Attorney General for this move, was simply because we felt that it would have given us an opportunity to find out where the illegal title had transferred. If you have gotten money illegally, that money cannot be transferred and legitimized. That's my understanding. And it's a common sense principle, I would think, that I can't come and take your money or steal your money and then go and give it to Adaudu, and then only for him to say, well, I don't know where the money came from, but as far as I'm concerned, he owes me money. he has given the money to me, and therefore it is now mine, and you cannot ask me to retrieve it. No, the law says, so long as that money that was taken was illegally taken, he cannot acquire title to it in whatever shape or form. He can convert the money to whatever it is he wants, but he cannot have title to anything that derives from that illegality. So once she had decided that she was going to do this, it seemed very, very clear that in the next case, in the next court that came up, which was going to be on the 10th of November, she would have a chance to actually get to the bottom of where Woyome had put that money after he took it, and why it is that we cannot retrieve it from wherever he has put it now. In a sense, well, I think what the AG is saying, that I don't believe you when you tell me that you do not know where that 51.2 million cedis has gone to. This is the case that it sits now. So if the AG now comes and says, I am going to discontinue this case, all right, but I want a door open that I'll come back to it, yeah, right? Nobody's saying that you cannot discontinue the case. What we are saying is that we do not believe that you will come back to it. All right, the credibility of the AG is now at stake here, because for the last so many years, first of all, you didn't pursue the case. Somebody else had to come and pursue the case. You didn't see any faults in the case. All right, you later on came and says, yes, you think you made a mistake. I'm going back to attorneys general and not necessarily any specific attorney general. This is what Betty Mould admitted when she was there. This is what happened when Amidou brought the case up and he was sacked. And this is what subsequently we are facing with the current Attorney General. So there's a credibility record which is there. Then there's the whole perception. There's the whole perception of that the money was taken presumably through a back door to enable Woyome to finance whatever it is he was going to finance. However, that because he was a well-known financier of the NDC government or the NDC party, there are question marks as to where that money ended. You see, there are two things here. There's the facts of the matter as to the contractual obligations which exist and which can be proved or disproved. Yeah. Then there's the perception arena, which is in the public domain, with all of this going backwards and forwards. If you ask anybody, even if you read what Ace has written on his page and how he has gone through and tried to explain it, even those of us who think that we have enough common sense and nuance to actually understand it, it's a bit convoluted. When you think there's a contract with Waterville, then there's no contract with Vermut, then there's a contract with Woyome, there was no contract with Woyome, there's been an arbitration. Was there really a contract to arbitrate? Most of us think no, there wasn't. You are saying there was an arbitration. So nobody seems to understand truly, apart from the lawyers who have been directly involved in this case, exactly how this whole transaction came about.
Considering that the court says don't pay, and then they went and paid. That's one thing which...
Yes, and that also sits there. That even the president says, you know, don't pay, and then somebody went and paid. So you have all of this sitting out there, all right? So you have such a credibility issue that you have to address. And then you get up and say, I'm going to discontinue the case. What do you really think people will say and think?
Now, maybe if I can quickly come
you can come in any time.
Because we are doing this for purpose of education.
Yeah, we need
for everybody to understand.
Absolutely.
I think in one breath, Sydney is saying that they congratulated the Attorney General on her efforts for filing a process that would examine Mr. Alfred Agbechi Woyome as to where the money is and how we can retrieve that money. In another breath, we are condemning the same person that why should you go and discontinue with leave, even asking for liberty, that I would come back.
I think there are two different breaths.
No, I'm coming. They are not. They are not.
Well,
you see, the AG would be privy to some information that we may not be privy to. She'll be privy to other things that, while she has been doing the execution and others, there will be some information she may have. And looking at it, and decides that, look, I think I have a better strategy in approaching this matter. If what is pending now, if I go that way, I may not be able to succeed. Look at it. I always say the law is the same that every lawyer uses. The only difference is how to distinguish it. But the key important thing in legal practice and others is that what is your strategy? What is your fallback plan? That when I go this way and there's an issue, how do I go about it? And I think one of the information that we have been given is that he's written some letter and looking at some proposal and say, give me an opportunity to meet you. Let's discuss this, how I pay. And she's giving us a notice that, okay, I will grant you some respite if we discuss it and I'm satisfied that you can pay this money, we would put it together. If I'm not satisfied, I'll come back to the same court. Now, so this is the issue. Okay, so if you look at it, in one breath, she's done well. In another breath, for me, it tells you that she is on course and doing something. Because if they praise you every time for doing something right, every time, you might not be doing it right. At the time, it will favor somebody. At the time, it will be against. But if you look at it on balanced scale, I think it should tell you that, yes, you are doing something that there's it. But I believe that the information and other things that would come to her custody would enable her act in a way we may not understand.
Sydney, are you satisfied with that?
No, you see, I think Adaudi is a very smart man. And he's trying to choke me somewhere. So I can't come out of there and go here. So let me go back there. No, it's logic. It's logic. So let's here. You see, he started off building the premise that it is how do you say it is like it's one breath. So if I accept that it is one breath, then it's not difficult for me to part the breaths.
So it's two breaths.
So if he gets me there, then it's but there are two breaths.
No.
See, there are two breaths because of this is the way I see the two separate things. The first attempt to file a process to get to the verbal interrogation would have helped the whole of this country appreciate and understand, all right, exactly where the money went. And you see, this is the thing. This particular breath that we are talking about, the people of Ghana want to know, they want to know whether or not Agbeshi Woyome took the money and pocketed it all by himself, or whether he took the money and he palmed some of it off to his political cronies. We need to know. Particularly, we want to know whether some of that money ended up in NDC coffers, which was the original thing that came out when this whole thing started 6 years ago. Did it end up there or did it not end up there? And the people of Ghana still are not clear where exactly this money went. That's one breath. So the second breath, which is the legal breath, is that you are filing for a discontinuance, all right, on a case that we all were expecting that some kind of judgment was going to come out of it as to Woyome. As to the actual collection of the money, if you ask any Ghanaian on the street today, they will tell you that they have no hope of ever getting that money. They know they are not going to see that money. All right? They've given up. Because after all these years, and with all the convolutions and the backwards and the forwards and the thing, everybody is convinced that this government will not under any circumstance do anything further to collect this money for the people of this country.
Let me find out something here before you continue. So, from a layman point of view, Sydney owes me and I've taken him to court and they're giving me a court date. And then Sydney writes to me to say, okay, no, come and let's talk. Don't I go and listen to him, and if what he says is good enough, I withdraw from the court, and if what is not good enough, I still take him to court. But to go and withdraw from the court, to come and now wait to see if you pay me or not, I don't get that.
Yes, and I think the lawyer should explain that to us. But this is the way I understand it. If there's a case in court, and then if you and I have a case in court, and let's say I'm the one who is being accused, right? You are accusing me, and the court has told me, all right, that I'm guilty, and he's asked me to come back to court, and then I get in touch with you, and I say, look, Nana, we can solve this by ourselves and move on. I think that the process works that we then go to the court, or else we then write to the court, and we say to the court, we have something that we are going to negotiate, and we can do it. But so we are asking you to give us a new date, and we will come to you with this new issue. That's one way. The other way is that the court will say, no, you want to do this, come and show me what it is you have, and let me be convinced that this that you are bringing to the table will solve the problem that we have, because we have already started this case. We are halfway through it, or 90% of the way through it, and I'm not prepared to waste any more court time going backwards and forwards and spending more money. So come and deal with this thing now, and let's sort it out. My layman common sense understanding is that.
I agree. That is what normally we refer to as consent judgment. When the parties agree and they say, oh, let's have time, let's settle the issue among us. So they will file a terms, the terms that they have agreed. So they themselves will file it and give it to the court, and the court will adopt it as its judgment. As its judgment. That's one matter. That's it's allowed.
Yes.
Now, it's a principle. I forgot my glasses. But you see, there's a civil procedure by Kwame Tetet, the learned author. It's a principle that the court should not itself encourage litigation.
Yes.
Right. Or the court cannot itself decide to instigate litigation.
This is from my junior lawyer. Now it says that Betty went to tell the court the state had no case. Later went back to say, now there's a case. The court then says, no, hold on, stagger the payment, but she went ahead and paid the full payment. I guess what she's trying to say is that this is not the ordinary, I bought a car from you and I didn't pay. Yes, it's a very sentimental case to the nation. Yes. So I think, I don't know if they are in applying the law, you forget about all these sentiments and just go by law, or there's something extra serious about this case.
You know, that sentiment, where the sentiment is coming from. It's all about perception. Because if you look at how the case traveled and got to, because it is believed that Mr. Woyome is a financier of the NDC party, right? If some money went to him and the people who were involved were also members of the party or executives of the government.
400,000 went into an account?
Yes. That is where the perception comes that, look, this money was used to finance. But there's no way it has ever been on record, put on record, that this money was paid to this person for party activities here and there. That's the perception. That is where there is some kind of confusion, that people believe that this money never got to maybe Mr. Woyome. It was money that was splitted within the party and the people. And every party, every government that comes has its own baggages, things that will follow it. These are things that you cannot run away from. Every government that comes would have baggages with it. Now, that is why even people felt that, look, Woyome was persecuted for criminal offenses, right? Then, at the criminal matter, we lost it. The state lost it. Because The case, when it got to Court of Appeal, dissected the issue and looked at the criminal distance and said no.
Was it not because Woyome was the only person, all the other parties were not called? The Attorney General, those who signed
There
the
were so
check.
many, there were so many question marks around that, around that.
You see, the
that
case,
whole case.
yes, in every case that you prosecute, that's why I have said in my preambles, or when I was saying that, everybody looks at the case. We quote the same law. What strategy are you looking at in pursuing your case? Your strategy may not work. The other person's strategy may work. It's just the same as when you are going as a defense counsel. You are looking at the strategy and drawing some legal traps for the person. So if the person falls into it, you win the day.
One breath, two breaths trap.
No. You see, so I understand the sentiment people have that look, it's just that a team of people sat down who belongs to NDC as a party or the government, they sat down and cooked all this and the money was paid.
Would they be wrong?
No, it's a perception.
No, but would they be wrong to have that perception?
Yes. Because when
President says don't pay, judge says don't pay, go behind, quickly pay the money?
No, president said don't pay.
Yeah.
But
Judge says stagger the payment.
judge says stagger the payment.
All was ignored and paid in full.
I don't think all were ignored.
Yeah, we're going to put the
I don't think all were ignored.
But it was paid and paid in full.
Yeah.
Yes, it was paid and paid in full. On what basis was it? I think that when they went to court, they asked that the matter should be, they should have some respite. That was when, whilst they filed the processes, and the judge was saying that, okay, we will hold on terms, pay on these terms, then you come back.
Yeah, but
Now, then they got that judgment, are you getting it? And used that judgment to say, look, we have this judgment, this is the terms that the judge has said, and this money was paid. The communication between the AG and the finance at that time, that it's something that I am not privy to, so I don't know how that went about.
No, but it's our money, so we don't care about their communication.
And that's why I'm saying that it is believed, and people believe honestly that some people are beneficiaries in this matter.
I'm saying
which it is not.
400,000 Ghana cedis,
yes, no.
was given to somebody's wife.
It was found. It was found in, but yes, if some money, I believe that some of his lawyers gave some explanation, which I think was not in tune with all people were saying. I get it, but I know that Iyoko came out and said they found some money in that.
Coming from Woyome to.
Now, the issue now is that whether you like it or not, the Supreme Court has spoken. It says that we do not have any contract with you. You have taken our money. Pay the money. The person who is supposed to make sure that the money is paid is the Attorney General. And the Attorney General has also started processes to make sure that we get the money. The difficulty in this now is that we can't, some properties has been attached, that other people are also laying claim to those properties that it belongs to them, it does not belong to him. We have some difficulty, and that's what the AG is also trying to find out. How best do I go so that I get my money from Mr. Woyome?
But wouldn't that be achieved in the Supreme Court if he's doing that oral thing? Say, look, this property is not mine, this is mine, this is not mine, this is mine.
Yes. And then he can be pinned down specifically to say.
And even if the people who has filed interpleaders, because the other cases, they will go and say, they would have to come and prove that this is how the property came to me, became my property. Or I have an encumbrance, or maybe he used that property as collateral to take some money from me. So I have an interest.
Yes.
And because I have an interest, until I take that my money, then you can also take yours. So it is a little bit complex.
So can you explain to me?
Yes.
Seeing as I don't understand it, how does filing a discontinuance of the case retrieve our money?
No, the discontinuance, I believe, my honest belief is that this discontinuance that has been filed, we've been given the reason that a letter has been written. He says that I want to pay the money. Now, if I want to pay, these are proposals that he will make proposal, or let's sit down, I'll make proposals that I'll pay this amount from this time to this time.
But sorry,
I believe that if this meeting, they sit down and the proposal he makes, it will not be shrouded in secrecy and come and say the man has made this proposal, we haven't got any money. And that is where the agency says, yes, if you are asking for an opportunity, a window to be heard, that this is what you want to do, we will give it to you. Let's meet. If we are not satisfied,
but
we will go back to court.
How gullible can the AG be when he was given an opportunity to pay the money back? He says he doesn't have the money. He was then found guilty, and then he's being asked to pay the money back, and he went back and filed to try and stop some process or the other. Then he goes back and says, I'll offer to pay this money back on terms and complete it over a certain period of time.
Yes.
Then the due date comes and he hasn't paid it. Then he comes back with another excuse and another reason of why he cannot pay it. Now here we are again when another case is being processed against you, another process is being filed against you. Then you come up and say, oh, here's a letter, here's my concern, this is another offer that I'm making. How gullible can you be that after all this going on, and for somebody who has been found to be a criminal?
No, he was not found to be a criminal.
Oh, but he committed a crime.
No.
What does the Supreme Court say?
No, what the Supreme Court says that there was no contract.
Yes.
So he should refund the money to the states. That was the civil matter. The criminal matters, we lost it. We lost all. From the High Court, the state lost it, and the Court of Appeal, the state lost it.
We, the people of Ghana, believe that the Attorney General lost the case because she did not put up a credible enough defense in order to be able to put all her forces on this thing to win. We think that there's a conspiracy not to win the case. And I think this is where the whole thing is coming. That there is a perception that there is a conspiracy from government not to win the case because there is this link between Agbushi Woyome and the NDC government.
Let me explain that.
We're dealing with a lot of complex perceptions.
Let me explain that quickly.
Just as the shortest break, and then we find out what Martin Amidu can do, because he took the case to court. I know he's not, I mean, if he's interested, then what can he do in these circumstances? Coming straight back. Well, with support from Ministry of Trade and Industry, Joy Prime TV brings you the maiden edition of the Made in Ghana Fair. Come and experience and appreciate our beautiful Ghanaian culture as exhibitors display their locally made artifacts. There will be good music, tasty food, refreshing drinks, all made in Ghana. Make it a point to be at the Junction Mall, Oguaa, from 4th to 5th November 2016, from 9 a.m. to 6 p.m. each day. And if you want to be part of this event, pick up a form from the desk of Multi TV or call 030-2211-680 or 0243-115109 to book your stand. Made in Ghana Fair is brought to you by Joy Prime and sponsored by Armada Company Limited, Akriti Ghana, Diana Hine Rice, by Winco, and supported by Home Food Processing Company Limited. Media partners are Hits FM, Adom FM, Joy FM, Asempa FM, Love FM, and Inshira FM. To my guest, you were.
I wanted to explain something that that AG pursued the case sharply. You know, there's some difficulties when it comes to our criminal prosecution. The position is that if I know somebody who is a witness who can even testify, which in legal parlance we'll say material witness, who when he says can turn the skills, that I have to call, and I don't even call that person. That person is at liberty to come or refuse. I cannot compel that person to come. Unlike in civil matters, that the court has power to say, appear before me, to answer some few issues. If you do not appear before me, the court has power to deal with it.
Now,
but when it comes to criminal, then the person can decide to come or not to come.
With the Supreme Court, now that the AG is already filed, can the Supreme Court still go ahead and call Woyome, or through with this discontinuance, you can call it?
No, the Supreme Court cannot on its own sumo to instigate litigation. The courts, it is not. It's against public policy. It's against. But I believe that the court would also want to know the reasons why you want to leave. You want to leave. That's why the court would say, file a motion, give me some reasons, come and argue, give it to your opponent, let your opponent also know the reasons why you want the leave. But they cannot say that continue or compel you to persecute the matter, or say that, look, we will litigate this matter. I don't think that will be the principle.
But my understanding is, at this particular point in time, there is a hearing on Thursday next week in the Supreme Court on the 10th.
Okay.
There is a hearing.
Okay.
And at that hearing, I believe, or if I understand the law in its simple terms, there is another party, an interested party in this case, which is Martin Amidou.
Martin has an interest in the
Martin has an interest in this case. So Martin, through whatever process or whatever procedure you guys have, can actually apply to the court for him to be allowed.
I think since he's a lawyer, he can always apply as an amicus.
Okay,
he will be allowed.
So
you may have something that you think that when you make that input, amicus is just saying that allow me to also make an input which will bring out a richer and sound judgment.
But he's in a more powerful, he's in a more powerful position to do this, is he not? Seeing as he was the one who actually got the case to the point where it is now.
I believe that he can always do it, and I don't think that the door to the shrine of justice will be shut.
Well, this has just
no. Before you do a roundup, if you may permit, if you can permit,
we will go like
we'll
2 seconds.
Charlie, 2 more minutes. Right?
No, but they'll cut us off.
You see, I believe that with the heightened perception of corruption that surrounds this case and the way it is going, I think the AG should just be a little bit more cautious as to how she proceeds and how she takes this case forward.
On that note,
because this is an explosive case, and she should be a little bit more careful.
And I would say
that is why Occupy Ghana.
Let me say thank you very much.
This whole thing.
But this has just begun, and I'm sure it's just an unfolding story, and things will come. The AG will probably bring the reasons why they're discontinuance, and then we'll see whether we accept it or not. But thank you for watching. Tomorrow we'll be back to do this all over again. And gentlemen, thank you so much.